Shooting to neutralize the threat. That is the claim of this defendant, and we are still waiting for this jury to come back into the courtroom with their decision. For now, let's bring in here in studio Court TV legal correspondent Kelly Craft joins us, as well as trial attorney Miguel Custodio is here from LA County. So glad to have you here on the show weighing in. We're waiting on this verdict to come in. Kelly, give us the details, because this was day 2 of deliberations for this jury, even though they only took a little bit of time overall as far as deliberating.
I was actually surprised, Julia, that they came back so soon this morning, because they only deliberated for a short time on Tuesday night. And then, of course, yesterday we had the Juneteenth holiday, and so courts were closed all across America. So today they came back this morning, and there's a big time difference between Atlanta and Las Vegas, so 3 hours behind in Las Vegas. I thought they'd go a little bit longer this morning, but then we heard right away that there was a verdict, because right even at noon our time, so 9 o'clock their time, they still hadn't reached a verdict, but soon thereafter, within about an hour after that, then they came to a decision. And keep in mind, one of the things that they're taking a look at is this is open murder. So the state, of course, talked about in its closing that this was premeditated. So is the jury going to think it was premeditated, which would be the first-degree murder? But they also can look at second-degree murder. They can look at voluntary manslaughter as well. But the state is wanting, of course, that first-degree murder conviction. They're saying this was not a heat of passion situation. She was not really in a situation where there had been any past incidents. She talked about that 156 times where no incidents at all. And then this change of custody request came, and then so she planned this. That's exactly what the state is wanting this jury to believe.
Yeah, and if it's self-defense, then it's a not guilty decision by this jury. Miguel, talk about the uniqueness and difficulty at times for a defendant when they're claiming self-defense and it's gotten this far. They weren't able to get the police to believe them, or even a judge in a motion to dismiss. They now have to give it to a jury.
It's very risky, and obviously it's very concerning for the defendant, because look, here we have 10 shots that were fired, and there's a motive. We have that motive. Earlier in that week, there was a petition filed for a change of custody, right? So it's really hard to say that this wasn't premeditated. We know by all accounts that the decedent was a very peaceful person. So it just seems that it's not a good look right now for the defendant.
Yeah, we have another person who's inside of the house, 2 people who are inside of the house. So you also have this claim of self-defense of other people, defense of others rather, in terms of what the defense is saying her reasoning was for trying to neutralize this threat, needing to. And we heard from the daughter who was upstairs of this defendant. Let's take a listen back to that minute.
You take your son back to the potty, is that right?
Yes.
And again, that's part of potty training, always taking your kids to make sure they don't have accidents. And does Ms. Bordeaux and Mr. Babbitt go with you to the bathroom area? So you go to the bathroom area, and then believe what you say is the last time you see Sean is he's upstairs, at the stairs, is that right?
I think he was upstairs.
Yes. And again, you don't hear any arguments. And is it fair to say that even before you get to the bathroom, or that you get to the toilet area, you hear loud bangs?
I was in the bathroom, but just not the toilet area.
And then you heard a bunch of loud bangs?
Several of, I don't know how many.
Right. And I think you told the police 2 to 3, but then said several.
So yeah, I don't know how many, I'm sorry.
Oh, that's okay. And you had no idea what happened? You're upstairs with your 3-year-old son.
That's right.
It's fair to say it was a very scary situation.
It was.
Again, is Erica Carnell. She's the daughter of the defendant. Kelly, we talked about demeanor and how the defendant appeared on the stand when she was testifying in her own defense, but her daughter really did bring emotion. Seemed to have those moments where she was breaking down in front of the jury, seemed very nervous about what all she was talking about. Complete opposite, really, when we heard her mother testify.
Soft-spoken demeanor from the daughter. And keep in mind, so the victim in this case, she was married to him, but now then she became pregnant with the this victim's boss. And that's one of the things defense counsel talked about in this situation, in this case. And so what a conflict for her on the stand testifying her mother's life is on the line. Then her ex-husband is now dead. She shares a son with this man. And just the connections are a little bit strange and very hard for her to talk about, obviously, on the stand. But I thought her testimony was good. She was very credible. She really said she didn't hear anything. And so how that plays with the jury in regard to, again, this, was there anything, was there an argument that you heard? I heard nothing. And so maybe that's good for defense in that she says, you know what, he just started charging at me. This was not premeditated. I didn't think about this. I was saving my life, and that I had that imminent danger, which is the key to self-defense.
It is such a hard question for this jury because they weren't there. There's no video of what happened inside of that home. And you're right, there's not even a witness upstairs who can say, I heard an argument, I heard what precipitated this, just the shots fired. Even the defendant, Miguel, when she was on the stand, she said, all of a sudden he's charging at me, and then I heard shots being fired. Her own shot. She's talking about them as if it's a third person, as if she's on the outside looking in. Can you talk about the quickness of this jury coming back? We're saying quick. You really can't know what a jury does in terms of their deliberation, if it's quick to them or if it's lengthy, but 2 hours and 41 minutes on a self-defense case. Your thoughts on what that could mean in terms of if this is going to be guilty or not guilty?
I think, and usually when the jury comes back quick, it turns to be guilty. And, you know, I think there's a lot of evidence here that stacks up against the defendant to show that it was premeditated. And clearly we were talking about the witness, or not witness, but the daughter that was upstairs didn't hear anything, right? So I think the jury can really infer that there was just really no argument, and it she knew what she was doing, and she did it.
Just happened. It's almost as if that's what the defense is. We're going to get in a break because we don't have that jury back yet, but stand by because as soon as it comes down, we are going to bring you there live. Our cameras are poised and ready for this defendant to come into the courtroom. This was nearly 30 minutes ago that we were told it was going to come down in about 15 minutes, so not sure if there are any hang-ups there inside of the courtroom, but we will bring that all to you. Also, the Karen Reed trial, we are keeping an eye on that. They are at the lunch break, but we will bring you back into that testimony when we get this verdict later today. So we're continuing to stand by. I want to bring in our guests who are waiting and watching with us. Court TV legal correspondent Kelly Craft is still with us, who's been following this case, and so is Miguel Custodio, trial attorney from California, who is here following along and watching with us. Miguel, we talked about the defendant taking the stand in this case, and that was a huge moment. The jury, no doubt, was hanging on every word from her, but that's a tough decision. Do you think there was any possibility that she could have not taken the stand and still achieved an acquittal in this case?
No, I think most criminal defense attorneys will not let their clients testify unless it's like a Hail Mary, where things aren't looking good, and the only way that maybe we can change the momentum of the case is by bringing her in. And her testimony, she seemed very cool, calm, no emotions, whereas with her daughter, it was definitely charged, it was emotional. And I don't think she really helped her case by testifying here in this case.
And Kelly, let me get your take as well. You're a former prosecutor. You looked at the background of this defendant. She's got a lot of credibility in terms of who she is. So there's a possibility she could not have decided to take the stand, but in self-defense cases, sometimes there's really not an option in the way that we're analyzing it. Your thoughts?
You know, one of the things that I liked watching her try to talk about on the stand was when the prosecutor asked her about manipulating the crime scene. Julia, you and I talked about this, and we wondered about that. The prosecutor brought that in. Pamela Boudreau was acting as if she was surprised. She says, this is the first time that I've ever heard about this. The state really was trying to emphasize to the jurors, not only that this was premeditated, that she had this whole thing planned, but then also she took that step further to manipulate that crime scene by placing a sock over his face and moved some cartridges around. That's what she was claiming, the prosecutor was claiming in this case. Pamela Boudreau was saying absolutely not, didn't touch a sock, don't even know anything about what you're talking about. I wonder how that's going to sit with the jury.
That was such a strange moment inside of the courtroom, because even if she did let's say, manipulate the scene, put the sock on his face, how would that have helped her case? How would that have helped her self-defense case? And let's go back, since you mentioned it, to that moment where police did arrive and asked her the all-important question of what happened here.
Before we head back into court, let's bring in trial attorney Miguel Custodio. Thank you so much again for being with us here on set, watching this. The first basic question I have is, what do you think of the defense's going after not just pointing the finger and saying someone in the house did this, but instead it's a massive cover-up, they're all involved? Is that a risk?
It is a risk, but I think there's enough connections in this case that the jury can actually run with that when they're deliberating. The personal connections that the lead investigator had, and it just goes to show that there may be something there. There was evidence that was found at the scene after the scene was cleared. Those things start bringing up some of that reasonable doubt.
I agree with you, and I think, too, the fact that, you know, things changed after the incident happened. They got rid of a dog that was in the house. They changed the flooring in the basement. Phones were cleared off, some of them. So all of those things may add up to conspiracy. But now let's talk specifically about this trooper's testimony, because you watched some of the direct. Now we're on cross-examination. I feel like the cross-examination is not necessarily as powerful as with some other witnesses. Do you think it's effective in this case?
I think he's actually doing a really good job of trying to chip away at what the prosecution was able to establish with Trooper Guarino. That being said, I think the cross-examination should be shorter, because you want to be powerful and you want to have that punch. And I think it's starting to drag on a little bit now, so it may actually not be as productive for the defense as they would like to.
Yeah, I would agree that a lot of this is going on a little longer than I think we might ideally want it to. You do plaintiff's work. You have to read juries all day long in your job. So, you know, Matt's been great about telling us what the jury's doing. They're taking notes during a lot of the cell phone analysis, and then they're kind of putting those down and listening as they're hearing more from this trooper. Tell me, are you ever able to read a jury in your experience, or is it more of you just don't know what they're going to do?
We think we know what they're thinking, but in reality, sometimes the ones that we think are going to go a certain way actually are not with you at all. So it's tough, but it's telling when the jurors put their notepads down and they actually start looking at the defendant, or they start looking at the witness. So we know that the jury actually started looking at the defendant when those voicemails were playing. So that's powerful, because I think it ties in with the prosecution's argument that this was somebody who was drunk, who was full of rage, who was volatile, and I think it does not play good for her.
I would agree with you. I think that those are detrimental to her case. Absolutely. You're going to stay here with us as we watch more. We're going to go back inside the courtroom for the trooper on the stand still. Guarino is being cross-examined. Let's see how he does. All right, still with me to break all this down, trial attorney Miguel Custodio. Let me ask you this, Miguel. The most damaging part of his testimony clearly is going to be those text messages where you hear Karen read. What do you think about her testifying or not testifying in this case?
Well, in this case, I think that those voicemails really make it a necessity for her to testify and explain herself. The problem with that is that we know from text messages, from voicemails, that she is a volatile person. And as a defense attorney, he's probably very nervous having her testify. And so I think it's going to be something that they're going to have to just make a last-minute decision. But with these voicemails, they're very incriminating for her. And so I think she needs to really explain herself.
Yeah, and she did say, she shared with the media, she was talking with our Matt Johnson, and said that's going to be an 11th hour decision for the attorneys, of course, because they want to hear everything the state's presented. And after that, then she's going to want to decide, or she'll defer to the attorneys. What about her talking to media quickly?
Scary. I think if I would not let her speak to the media. You don't know what she's going to say or if she's going to get riled up, and I think that's very dangerous, especially if she's going to take the stand.
Absolutely agree with you. Thank you so much, especially for being here in person. Goodbye to Miguel Custodio. And up next, Michael Ayala joining me as we bring you more of the trial from Karen Read. Stay tuned. We'll be right back.